Good morning. This is your Kelso Report for Thursday, June 21st. I'm your host, Clark Kelso. We got three cases that were decided yesterday. A couple from the Ninth Circuit, one from the Court of Appeal that we'll be reviewing. First, we begin with the Ninth Circuit, a case involving supervisorial liability against government. The plaintiffs brought a Bivens action against both Border Patrol agents who stopped their shuttle repeatedly as it crossed the border, and arguably in violation of their Fourth Amendment rights, and the supervisors who reviewed and directed the stops. One of the supervisors directly participated in the stops, but the others were simply aware of the stops and approved them. Now, the Supreme Court has previously held that there is no respondeat superior liability in a Bivens claim. So a supervisor can be held liable only if the supervisor has personally violated the applicable substantive law, in this case the Fourth Amendment. So applying that approach, the Ninth Circuit held that mere conclusory allegations of liability in the complaint were insufficient, except as to the one supervisor who directly participated in the stops. As to all of the other supervisors, mere allegations that they were liable was insufficient. You had to allege facts showing that they had actually violated the Fourth Amendment. Our next case is an ERISA case involving the scope of remedies under ERISA. Now, ERISA's remedial provision authorizes courts to enjoin any act or practice which violates ERISA or the terms of an ERISA plan, or to enter, quote, other appropriate relief, close quote, to enforce a plan. In CGI Technologies and Solutions v. Rose, the terms of the plan expressly disclaimed the application of certain traditional equitable defenses, such as the make-whole and common fund doctrines. Defenses that would have otherwise applied in this case in favor of the beneficiary. Following the Third Circuit, but contrary to several other circuits, a split panel of the Ninth Circuit held that a district court, in granting, quote, appropriate equitable relief, close quote, may consider traditional equitable defenses, notwithstanding express terms in the plan disclaiming the application of those equitable defenses. On remand, the district court will consider the plan language in fashioning relief, so you don't entirely ignore the terms of the plan. But under the Ninth Circuit's holding, the contract language is not as sacrosanct as it otherwise would be, and the district court can enter an order contrary to the plan language but consistent with principles of certain equitable defenses. We now have a very good split among the circuits on this question of whether a court can order or other equitable relief recognizing equitable defenses notwithstanding language in the plan. And this is an important legal question, which I believe the United States Supreme Court will now soon take up to resolve an important conflict in the circuits. Next, we turn to the California Court of Appeal, a collateral estoppel case. The plaintiff in Direct Shopping Network v. James filed a defamation and trade libel action against two authors who had published critical stories about certain gems sold on the plaintiff's TV show. Both authors filed anti-SLAPP motions. The motions were denied by the Superior Court, and one of the authors took an appeal ahead of the other. The Superior Court stayed the rest of the action with respect to the other author pending the appeal. The Second District held on appeal that the anti-SLAPP motion should have been granted, and it remanded and directed that it be granted. The plaintiff then, with that opinion in hand, asked to introduce new evidence against the other author's anti-SLAPP motion, which the Superior Court permitted, and the court then granted judgment on the motion for the plaintiff. On appeal from that judgment, the Second District held that the plaintiff was collaterally estopped from the prior remand to relitigate the anti-SLAPP motion using the 2nd District's first opinion as a roadmap for now opposing the anti-SLAPP motion, since the issues in both anti-SLAPP motions were substantially the same. That's it for today's Kelso Report. Have a great day in the law, and we'll see you tomorrow when we'll very likely will have a big chunk of U.S. Supreme Court decisions, perhaps even the healthcare decision, although odds are the Supreme Court will release that one on its final day of the term next week. Have a great day in the law.